Welcome back to the People's Law School, an educational program that has been presented since 1985 by the Alabama Trial Lawyers, now known as the Alabama Association for Justice. We bring to you the best lawyers in America. Tonight is no exception. Kerri Riley is one of the best lawyers in America. I want you to know that she's the only lawyer I know who has tried a case in state court to a jury this side of Birmingham and actually gotten a verdict in a sexual harassment case. She's going to talk to you tonight about employment law. She knows a lot about it. Kerri is a real trial lawyer. She's been trying cases in the trial courts for over a quarter of a century. To let you know the level at which she practices, Kerri was she's from Huntsville. She's the valedictorian of her high school class, went on to graduate from the University of Alabama in chemical engineering, where she graduated with honors and again has practiced, but somewhere in between she has 3 children, 2 grandchildren, and just got off the airplane about an hour ago from Delaware, where she was visiting with her latest grandson, whose name is Anthony. Her other grandson is James, who is 11 months old, but Kerri's mighty proud of both of them, and she's a busy lady. But tonight she's going to talk to us not only about employment law, but its particular aspects, which are in regard to the sexual harassment area, but particularly about something that is very relevant and is new, and that is what are your rights in regard to the electronics that you have and that you carry. So it is my honor and privilege to present to you tonight Ms. Kerri Riley. Thank you.
Good evening. Thank you for having me back again this year. I always enjoy this very much. Let me just add a few things to what Alan so kindly introduced me as. I am in private practice here in Huntsville, and thank you, Alan, for pointing out how many years that I have been in practice. It's always nice to have friends. But at any rate, my practice is a civil litigation practice, and I do all manner of civil litigation. But I do seem to have a concentration in employment law, and particularly I tend to get a lot of sex harassment cases. So I'm here, I guess, to spice up the beginning of this program. As always, we know sex sells. Tonight I'm going to talk to you about invasion of privacy in particular, rather than give the same lecture I've given previously, although I'll be glad to take general questions about Title VII, the federal court system, and age, sex, race, disability, and etc. discrimination. But tonight I want to focus a little bit about invasion of privacy. My experience with invasion of privacy has customarily been in the sexual harassment context as a part of a sexual harassment case. But recently there's been renewed focus on invasion of privacy in the workplace because of all of the electronic communication and media that we have, and the law has begun, and it's just in its infancy really, but begun to catch up with our technology and to make some rules and laws, and then a few cases on what employee rights are in the workplace with regard to their privacy and an employer's invasion of that privacy. So the invasion of privacy tort is expanding, and I find that real interesting. So I'm going to start first explaining just classic invasion of privacy and talk about some of those cases, and then move into the workplace aspects of invasion of privacy. And some of you engineers, or any of you with teenage children, may have to help me with some of the technical aspects of this, because I'm no computer whiz. I had a slide rule, but we don't want to talk about that. Okay, and in deference to my grandmotherhood, I have to wear these. Invasion of privacy is a classic tort in the state of Alabama. It's not codified, it's in the common law, and it consists of 4 different varieties. Intruding upon someone's physical solitude or seclusion, and that's a broad thing. It doesn't just mean going into their house or disturbing them. I'll talk about a little bit more about that later. It can mean giving publicity to private information about someone that violates ordinary decency. And ordinary decency means what you and I and the common average person would consider to be decent in the community. So that standard can change a little bit from time to time. It can mean putting someone in a false light in the public, but not necessarily rising to the level of defamation. And it can also mean appropriating someone's personality for commercial use, and I won't really talk about that. It's not relevant to what I'm talking about tonight. In the state of Alabama, we have a body of law called the Restatement. Has anybody ever talked to you about the Restatement of law? Well, legal scholars throughout the country from time to time have gathered the law as a complete body of law in different areas such as contracts, torts, what have you, into what is commonly understood as to being the law in the United States. It's not necessarily what each state's law is, but it's a general statement of the law. And many times the states adopt that restatement of the law as their law. And Alabama has done that as far as the invasion of privacy tort is concerned. So I will give you the definition of wrongful intrusion into someone's physical solitude or seclusion that the restatement says, because Alabama, by its case law, have adopted that as our law. And that is one who intentionally intrudes, physically or otherwise, upon the solitude or seclusion of another or his private affairs or concerns. If that intrusion would be highly offensive to a reasonable person, and in cases, of course, each one of those words means something and is litigated and fought over, getting to actually present your case to a jury, having convinced a judge that your case has met each one of those words and the test for each one of those words sometimes can be very, very difficult. And what that means further is that it talks about eavesdropping, wiretapping, investigating into somebody's private concerns, opening their mail, examining their bank account records, things of that nature. But there's only liability if, and only if, it would be highly offensive to a reasonable person. And as I said just a second ago, and I'll repeat that, the question of whether it would be highly offensive to a reasonable person, that's not up to the reasonable 12 people on the jury. That's up to the judge. The judge decides as a matter of law, would this be highly offensive to a reasonable person? If his or her answer as the judge is yes, then the 12 people on the jury get to decide. And if his or her answer is no, then the plaintiff's lawyer usually appeals. So, but we don't get to have our trial. The court looks at 3 different factors when they're deciding if they're going to send an invasion of privacy case to the jury to be decided. Whether the subject matter of the intrusion is information that's private or should be private. The means of the intrusion, how offensive was that? You know, did you have a telephoto lens and were you peeking in somebody's house? That's highly offensive. And the purpose for which the information was obtained. That's going to be important a little bit later in the workplace context, where you'll find that an employer many times has a reasonable purpose in obtaining private information about the employees, and that many times the employer's purpose trumps the employee's privacy rights. But we'll get to that in a minute. The court has to balance the interests here, and then they decide if this case is egregious enough that a jury can then decide. So you have a 2-step decision process to a verdict if you feel that your privacy has been wrongfully invaded. Now, of these different types of invasion of privacy, giving publicity to private information, again, Alabama's picked up restatement law and has, in another case, said we're going to use the restatement definition of what that means. One who gives publicity to a matter concerning the private life of another is liable to that person if the matter is highly offensive and not of legitimate concern to the public. And publicity means something different than publication. We talked about this being a tort that can be wrongful, and liability can attach even if it doesn't rise to the level of defamation of character, which is a different tort. And publicity is the key word in those differences. Publicity is not publication. Publication for defamation has a distinct definition. Publicity means the matter is made public or is disseminated in a fashion that it's meant to be made public. Defamation can occur if you say something that's defamatory to a person, one person, and it's proved, which the proof can be hard. But in this invasion of privacy context, you're looking at whether something is meant to be given publicity, is meant to be made public, which means you could tell it to one person and maybe you didn't mean that to be public and you wouldn't be guilty of invading someone's privacy. Or even it says a small group of people could be told this very private information, and it would not necessarily be meant to be made public, so it wouldn't necessarily rise to the level of an invasion of privacy. And I thought of that when I read this. I thought of that as the gossip exception. You know, you gossip, but maybe you haven't invaded somebody's privacy. Although I've always thought if you gossip, then you probably meant for it to be public. You just didn't meant for it to be traced back to you. So anyway. It's not an invasion of privacy to communicate a fact concerning a plaintiff's private life to a single person or a small group of persons in the absence of the intent or the design for it to become public. If you put it in a newspaper or any means of written public information, then of course it can be an invasion of privacy. And this would of course be private information that's meant to remain private, that any reasonable person would want to remain private. The third, I believe, type of invasion of privacy that I wanted to talk about was the false light invasion of privacy. That type of scenario where a situation can rise to the level of a tort in the state of Alabama, because we're not going to talk about appropriating somebody's image for, you know, commercial use. That's probably better seen in Hollywood than here. But again, we've looked to the restatement in the state of Alabama. False light invasion of privacy. Liability can attach when someone gives publicity to a matter concerning someone else that puts that person in a false light. And again, that false light would be highly offensive. Highly offensive to a reasonable person is key in the tort of invasion of privacy. And whoever did this knew or should have known that this was false and that nobody would have wanted this publicized. Now, some interesting fact situations, and I keyed in. I'll talk to you just a few minutes about sex harassment cases. This isn't in my outline because I was focusing on workplace issues, but my experience has been in the invasion of privacy tort, and when I've had a verdict for invasion of privacy, it's been in the context of a sex harassment type of scenario. And what has risen to the invasion of privacy have been inappropriate questions about someone's personal life. Inappropriate questions about their marital life, inappropriate questions about the boyfriends or what you're doing on the weekends, and I won't go into any more detail than that because this is the family hour. But some of the questions can be quite explicit and quite offensive, and usually I have encountered this tort in the same fact situation as a sexual harassment case. Also, running along with sex harassment invasion of privacy is intentional infliction of emotional distress, because the people that I have brought cases for and we've been successful for have found all of this to be highly upsetting, and the courts have and the juries have found that the person who did this ought to have, although frequently they profess that they could never have understood how this could have upset anyone, but frequently the courts and the juries have disagreed and found that these sorts of questions are upsetting, and any reasonable person ought to have known that they were upsetting. And to digress just a little bit, because I keep talking about sex harassment, what I'm talking about when I'm talking about a sexual harassment case in the classic sense is a case brought in the federal courts under Title VII. Title VII is the law that most of us are familiar with in one form or another, because in our workplaces there's a big poster and it says, "We do not discriminate based upon age, race, sex, national origin, disability, religion," and on and on. That law that we all see the posters about is Title VII. And in order to fall under the protections of Title VII, your employer has to employ at least 15 people. If the employer does not employ 15 people, then there's no Title VII protection. And this is something that many people really just don't know, because that law is out there and everybody really pretty much knows about it, and they assume it covers everybody. But guess what? It doesn't. If the employer has 14 or less, they are exempt. They're not covered by Title VII, and so an employer with less than 15 employees can discriminate if they want to, based upon age, based upon sex, based upon race, based upon disability, and there's no liability for that unless your state comes in and provides some sort of liability under state law or through the common law that then has been interpreted in case law to apply to your state. Now, Alabama, in its enlightenment, has recently, now wave my granny glasses around here, has recently enacted a law prohibiting age discrimination. So if you're discriminated against because of your age and your employer has fewer than 15 employees, then you are covered. You can sue in federal court under Title VII. You can sue in state court under Alabama law. Tough luck if it's because of your sex or because of your race or because of your religion or your disability or whatever. We are not that enlightened. So now, and to go further, have anybody talked to you about employment at will versus a right to work state? Well, that's another little thing that, again, it's not my outline for tonight, but it's basic employment law, and many people do not know this, particularly our newest Huntsville residents from up north of the Mason-Dixon line. They come down here, and God bless all the Yankees, but they come from states usually where they have a right to, now y'all are laughing at me, they have a right to work. And unless you do something wrong in the workplace, and unless your employer documents that you've done something wrong, then you can't get fired, you know. And that's something separate from union, but many northern states are also unionized to a far greater degree than we are in Alabama. And so, you know, if you get fired, you have a bunch of union protections too. So it comes as a great shock to many of my clients who come in, and I, as a part of my practice, and I don't really know anybody else in this city that does that, but as a part of my practice, I frequently counsel people on employment issues. Lawyers, you know, historically have two roles, and we always think of the advocacy role, and Rambo and all of that, but we also are counselors sometimes on the law. And I frequently counsel people, because there's a huge need for it, about their employment issues and in the employment context. They come in and they say, you know, I don't know what to do about this situation. I don't know what to do about that situation. I think I might be fired, you know, and sometimes I listen to them and say, yea, verily, I think you're about to be fired. You know, you better make a plan. And that is where this, this right to work versus employment at will comes in, because in states where you have a right to work, again, you have to do something wrong to get fired. In Alabama, you don't have to do anything wrong to get fired. This is an employment at will state, and that means that your employer can terminate you in the absence of an employment contract, which most of us don't have, for any reason at all. A good reason, a bad reason, a wrong reason, because they want to give your job to their brother-in-law, because you have blue eyes and they want to hire only brown-eyed people. You know, any reason at all. And although I say this, in the moment, it's very hard for people to grasp, but they're actually going to get fired when they've been really a good employee, sometimes a stellar employee. They haven't done anything wrong, and they're going to get canned. You know, and that's really hard to understand. But that is the state of the law in the state of Alabama. Okay, well, at any rate, because we're an employment at will case, a state, people, especially in small businesses and small firms, are very vulnerable in their jobs. And I see that frequently women are very vulnerable in their jobs. And then you add perhaps someone who's financially precarious, single parent, all you know, transportation, child issues, whatever, and they really feel like they have to hang on to that job, and it makes them vulnerable to sex harassment issues when the employer is of that type of personality that they want to inflict that on someone else. So that is why it's very important to find a way in Alabama to redress those wrongs, to address them in the courts when the employer has less than 15 employees, because otherwise, you know, these folks are just stuck. And by and large, they are women, although we do see female on male sex harassment, and more of it, I regret to say. And we do see some same-sex sex harassment, although not so much of that in my practice, but I have seen a case or two. So what you have to do, because you can't go to federal court, can't bring this case under Title VII, you have to craft the traditional state torts that are wrong into a sex harassment case, although it is really not a sex harassment case. What it really is an invasion of privacy case, because you've been talked to and questioned about things that are just highly inappropriate, or the employer or a supervisor who has some authority over you, that the employer is responsible for, has shared inappropriately. That can also be an invasion of your privacy for you to have to sit there and listen to someone's exploits, and we'll leave it at that. So you have to craft that into the sex harassment case, and these are usually invasion of privacy, intentional infliction of emotional distress, and then occasionally, I regret to say, assault. Or assault and battery, which is an actual touching of, you know, inappropriate things. And these are the kinds of cases that I end up bringing in state court, because you can't bring them in federal court, and I've learned how to do it. You know, I've had some success at that. Okay. Now, how many of you work in an environment where your employer provides you with email, internet access, or some other type of electronic communication? Let's see a show of hands. A whole lot of you. Okay, other than email and internet, any other types of electronic communication employer provided?
Cell phone.
Cell phone. What else? Anybody else? What? BlackBerry, yeah. So working remotely. Any of you work remotely from home? Anybody provide, use your home computer for business use? I do, okay. Anybody provided a laptop to take home? Yeah. How about GPS? Anybody have GPS in their workplace? How about, does anybody have one of those little chips in their dog? Okay. Do you know that in other countries they are putting them in people? They are. You know this. They know this. Okay, this is the coming thing, apparently. Maybe, maybe not here, but if we get desperate enough for jobs, maybe so. Pardon? Pardon?
Didn't they do a family in Florida down around Palm Beach area?
A family did it?
A family in Florida, yeah.
Did it for themselves?
So I think there was a test thing.
Oh, there was a test thing, a test for families, a family in Florida that they implanted. What? Microchipped the family? The children. They microchipped the children. Yeah, for fear of kidnapping, I suppose. Well, one of the coming things is that instead of punching a time card, you would just like have a chip in you if you worked for some major employer, and they would know when you showed up and when you went to work and when you were at your desk and when you were down at the cooler and when you went to the bathroom and whatever. So anyway, as you can see, the technology is ahead of the law and ahead of the ethical concerns of privacy, assuming that we have any privacy in this day and time. What do y'all think about that? I mean, can you imagine being chipped for work? Yeah. But anyway, that may be where it's headed. So.
I think there's some positives, especially with children.
You think there's some positives, especially with children?
Kids get lost, kids get kidnapped, whatever.
Kids get lost, kids get kidnapped. Yeah, and we do that because we all love our children, and then those kids are chipped for life, and then the employer takes advantage of it, and there you have it. It's changing. Life is changing. Pardon?
When they turn 21, they can remove it.
Oh, when they turn 21, they can remove it. Yeah, or tattoo over it or something like that. I don't know. Okay, then. All right. Well, at any rate, I don't want to see a show of hands on this, but I assume no one in this room ever goofs off on company time using the internet or the email or whatever. Yeah, right. All right. Who has some idea of what statistically the percentages are, the goof-off percentages are for an employee's time on their internet use? Work time on internet versus goof-off time. Anybody got any idea what it shows statistically?
75% goof-off.
Bingo, 75% goof-off. How did you know that? Give him an A. He's laughing. Okay, give him an A. He gets an A. Or we won't tell his employer, whatever. Okay, well, naturally employers have a legitimate interest in monitoring an employee's use of electronic communications, and some of those reasons are really, they're good reasons. Email can and unfortunately frequently is used to harass coworkers. Happens. An employer has a legitimate interest in monitoring email use to make sure that they're not subjecting themselves to Title VII liability for a harassment of coworker. Misappropriation of trade secrets or other confidential information. I mean, you're sitting at your desk, you know. Some employees planning on starting a competing business, and they just PDF that info and zip it off to their home computer, and they've got it. So an employer has a very legitimate interest in preventing and in monitoring email use to prevent something like that. Theft or embezzlement of company property, that's kind of the same thing, except maybe it's not secret or proprietary, but it still belongs to the employer. Identity theft, I don't quite understand that one, but they have an interest in preventing sabotage. You know, I always think they're excessively worried about that. When I get clients who've been terminated and after umpteen years they've been marched out of their office in the company of some HR person, like a criminal. But, you know, I guess it does happen sometimes, and they have an interest in preventing that. Copyright violations and just goofing off. They have a legitimate interest in making sure their employees do not goof off too much. And so employers are having to figure out what the law is, even though it's in its infancy, kind of project what the law might be, and implement policies for using computers and cell phones and internet and blogging. And nobody mentioned IMing and texting, but who IMs and texts on the job? Does anybody have a boss who texts them or IMs them? Yeah, one person. Who can even text in this room? Wait, I see some people can do it. I've done it once. I was so proud of myself. I mean, I called everybody I knew. I text. Memory sticks, you know, those little sticks that, yeah, those things. And then sometimes GPS, or the chips are called RFID devices. Now, what on earth? Radio frequency identification. That's what those things are called, the little chips. Okay, so the employer has a legitimate interest in monitoring the use of those things and in formulating policies regarding the use of those things. And employers can and have been sued by employees whenever they have intercepted email or have learned personal information or just information the employee didn't want them to have. Through the monitoring of electronic communications. But courts have come in and they've really come down hard in favor of employers and have said that there is a diminished expectation of privacy in the workplace. And so usually liability, and I looked for some cases, there are very few where the employer was found liable. Most of the time the employee was found to be in the wrong. But occasionally when there was an intensely personal and private matter and the employer monitored and really monitored excessively or far beyond the point in time when they realized it was a private matter and any decent person would have just hung up the phone or cut off the tape or whatever, then there have been occasions when the courts have found liability on the part of the employers. The intrusion has been wrongful when the means that the information is gathered have been highly intrusive, as well as when the employer's purpose has been wrongful. And I'll give you some examples of that. Now again, federal law, and I regret to tell you that I didn't check to see if this law covers all employers or only employers of a certain number of employees. So that's something I'll need to check and add to my outline for next year. But federal law has been enacted called the Electronic Communications Privacy Act, and it prohibits unauthorized interception of electronic communications. And it covers broadly, but there are exceptions that employers can make use of so that they don't fall afoul of this federal act and liability can't be found against the employer. But broadly, it prohibits unauthorized access and disclosure of electronic and wire communications, and that would cover email, voicemail, all of that. Now, the exceptions are the provider exception, which covers employees that provide internet service to the employees. However, there's been some question about whether that covers employers who provide the internet via a third-party internet service provider. And again, when you're dealing with the federal law, you're dealing with each word. So what does it mean? And so we don't know if it covers that or not. There's an ordinary course of business exception, and there's been some litigation on what is in the ordinary course of business and whether or not an employer can be found liable under this law. And it's basically an invasion of the employee's privacy, but it's under the Electronic Communications Privacy Act for things that the employer says are in the ordinary course of business. And it has been interesting to learn that everything the employer does routinely and says, well, we always do this, is not necessarily under the law the ordinary course of business. So I'll get into that a little bit too. I have a case on that. And then the consent exception. Of course, you can consent. And the prudent employer are now, if they have not already, drafting broad consents for their employees to sign right along with your employee handbook. You'll be signing a consent to the monitoring of all your electronic communication. And I see the head nodding. How many of you have signed one of those in your workplace? Yeah, okay. Y'all got good lawyers in your company. So, and the rest of you probably will get there. And they will be broadly drafted to cover, everything that we've talked about. The memory sticks, the work at home, the internet sites you might visit, everything that you might do on company time. And that is to keep the employer from being liable under this Electronic Communications Privacy Act. Now, for example, under the ordinary course of business, and telephones, the law is mostly on telephones. There's very little on internet and voicemail because telephones we've had around a long time and we haven't had the email and the voicemail for so long. But the employer will monitor telephone calls, and they're allowed to do that. But they're only allowed to do that up to the point at which they can determine that this is a personal call. And then the point at which they determine this is personal call, they're supposed to stop monitoring. It can be an invasion of your privacy or a violation of Electronic Communications Privacy Act or some other wrong in the law that some creative lawyer will think of to monitor a personal call once the employer knows or ought to know that it's personal and not a business-related call. Because employers are presumed, if they provide a phone to their employee and they work at a desk, they're presumed to know that sometimes you're going to get personal calls at work. Even if it's only 2 minutes for your child to call at 3:30 saying, Mom, I got home. Or, there's a tornado and we're all being sent home, or whatever. That you are presumed to have some occasions when there are going to be some personal calls. And the employer is not supposed to just broadly tape or monitor all personal calls. And if I can find, can you say that again? How does it apply to the federal government? The Electronic Communications Privacy Act. If you are a federal government employee, then I don't know the answer to that. If you are a contractor employee, yeah, it should apply to you. Federal government employees, and I do limited representation of the federal government employees because their administrative process is long and, if I do say so myself, miserable. But it really is, and there are 9 million ways to kick the poor employee out of court or out of the administrative process in such a fashion that they can't ever make it to court before you get there. But I have done a few in rare instances. Yes?
In the federal government, most of the computers that I've seen have had a warning that says, use of this computer implies consent.
Yeah. Yeah. Well, and there is some case, in the federal government context, this gentleman says most of the computers say use of this computer implies consent. They're warning you, so be warned. There is some case law that suggests that even if you don't obtain a signed consent from the employee, if you just distribute the policy to everyone, and they get it, and they continue working the next day, then they are deemed to have consented. And in Alabama, I think we'd be particularly vulnerable to that because, again, we're employment at will. So, which means, you know, you don't like it, there's the door in this state. But the better practice is to get a consent. Someone else had a hand? Maybe not. Yes.
Do you believe the Justice Department should be able to compel disclosure of emails between federal employees?
Do I believe the Justice Department should be able to compel disclosure of emails?
Investigations, for instance, the Scooter Libby affair was one that comes to mind, where someone is always wanting to go in and look at all email traffic in a particular office. That seems like an invasion of privacy to me. Either that or someone should be very, very careful what they put in an email.
Yeah. The question was about, did I think the Justice Department should be able to compel production of emails between all employees in investigations, and frankly, that's sort of beyond the scope of this discussion because it bears on the different branches of government and the political process, rather than, and it like should the Justice Department be able to make its employees cough up all the email of Justice Department employees? Well, yes, that's what we're talking about here. The other question I'd probably rather address off camera. But anyway, and the gentleman's comment was also, if they can, then people better be very careful what they put in emails. And if I can leave you with one bit of advice tonight, it would be very careful of what you put in an email, okay? You better do that. There are some cases, and I'll be quick because we're about to run out of time. I've talked a little too long, I guess. But one particular case that comes to mind, an employee sued after termination for invasion of privacy. They were fired because they had been told by the employer, well, your email's private, and they'd been given passwords and told how to protect their files, and said, well, my email's private. So the employee, this person was, you know, a brain surgeon, I guess, emailed all these nasty comments about upper management to his immediate supervisor, you know, who I guess he thought was his best friend. I don't know what people do. And then, of course, gee golly whiz, I guess the supervisor maybe even didn't pass it on, that wasn't part of the case, but upper management found out about it and said, no, you know, we have not invaded your privacy to intercept those emails. It's our email system. And you can't berate and write derogatory things about us to your supervisor and get away with it. And they canned the guy. So he sued for invasion of privacy, and needless to say, he lost. It really doesn't matter if the employer tells you that your email is private and it gives you passwords and whatever. You don't need to write, and this is the dumbest employer I've ever worked for, in company email. So don't do that. That was really, really foolish. Those are the kinds of cases that we're seeing, and they just are not successful for these employees. And then I'll give you one case that was successful for an employee, and this one kind of falls in that it has a flavor of sex harassment. It didn't talk about sex harassment, but my sixth sense about this was that this guy was setting this woman up. The employer was monitoring surreptitiously a woman's telephone conversations at work, and she was having domestic problems, as all the case said, domestic problems with her husband. And she took great pains to not tell anybody in the workplace what was going on, be professional about it. She was private about it, didn't tell the employer what was going on. But the employer, the male employer, male boss, kept asking and asking and asking and nitpicking and trying to get her to talk about it. And he betrayed the monitoring by having too much knowledge that he couldn't have gotten from anywhere because she'd been very private about it. My sixth sense was saying, and he's preying on her. That's a predator trying to move in for the sex harassment as soon as the husband's out of the picture, or he's going to console her, or whatever his plan was. That was not in the case, but that was the context, and the flavor of that was all through that case. And the courts sent that one to the jury. It survived summary judgment. It was upheld on appeal. They said, you know, you don't get to surreptitiously monitor these telephone conversations for your own private satisfaction about this woman's personal domestic problem whenever she'd taken great pains to keep it private. So that's wrongful. It was the means of the intrusion, and it was also the purpose of the intrusion, which there was no good purpose for that. Then we have, and this is one more that many of you will probably unfortunately be familiar with. If anybody invents a spam blocker that's economical and that will work and keep me from getting all of these advertisements for various things that I won't say because, again, it's the family hour. But, you know, what do you do with all that mess? Or, you know, well, what you do is you delete it. And you spend a lot of time deleting it. This particular lady, and there's a case on that, and I'll close with this one and take questions, but she again had been told her emails would be private and she had password protection, and she thought, well, I can do anything she wanted. So she would get all these little off-color jokes from internet sites and some of the pictures and things that I'm sure, unfortunately, we've all seen. Well, she thought they were hilarious, and she's forwarded them to her coworkers, you know. And the employer, which don't do that, because the employer, that can be, you know, it can be sex harassment. It can be an invasion of somebody's privacy, actually, for them to open that up, and it's been forwarded to them, and that's in their face, and there's nothing they can do about it at that point. And the employer was monitoring that email and fired her. Well, she sued for invasion of privacy. Said, well, that was private. Well, you know, the court said, no, that was not private. It's employer-owned computer and employer time, and you just can't do that. So the expectation of privacy in that context was not reasonable. And those cases, of course, didn't even go to a jury. The judge threw them out. Let's see if I've got just one more quick one maybe. I wanted to mention because it was interesting. Oh, there was a case where there was a sexual harassment investigation, and this is not good for sexual harassment plaintiffs. Whenever you hear about women bringing sexual harassment complaints, and I frequently hear, oh, you know, they're spurious, you know, people making stuff up, anybody can say anything, but there can be really strong repercussions for bringing complaints, and oftentimes the law doesn't, even though you're supposed to not be retaliated against, oftentimes there's no real redress. The retaliation occurs or the adverse consequence occurs and there's nothing you can do about it. And this is a case where the lady brought a sexual harassment complaint, and the company investigated, as they are supposed to do. Well, and in the course of that investigation, they talked to the supervisors of this lady, which they had to do. And the supervisors learned that the lady had brought a sexual harassment complaint, which, how could you prevent them from? They had to interview them. Well, after that, the supervisors said, we don't want to work with her. We're not working with her. You know, she brings sexual harassment complaints. And so this poor woman then brought a case for invasion of privacy because nobody wanted to work with her. And the court said that was not an invasion of privacy. The company had done what they were supposed to do, so she just had to be in that environment. Now, whether that would be retaliatory if they actually didn't work with her, probably so. But the fact that they didn't want to and didn't talk to her anymore and whatever, that was just a problem for this woman. So Anyway, at this point, I've just about run out of time. Does anybody have any questions or comments? Shirley.
In this sexual harassment situation, we've had cases in the city of Huntsville in which individuals bring against the supervisors. Is the burden of proof real heavy on the plaintiff? You know, because sometimes it's difficult to get a good judgment against the individual. So the burden of proof is on the individual that brings the complaint, right?
Oh, yes. The question is, on whom is the burden of proof when bringing a sexual harassment complaint? And the answer is the plaintiff, the person bringing that complaint. And that's always the case. That is always the case in any civil litigation where one person brings a charge against the other. The person bringing that charge or claim, the plaintiff, bears the burden of proof. If the evidence is equal, guess who loses? It is the plaintiff. So it's not so easy as you think. Anybody else? Did that answer your question?
You know, Kerri, my observation is that you talk about the expectation of privacy in regard to these electronics, and it seems to be exactly what the law is in regard to them being able to search your desk. In other words, just because you have things that are private in your desk, the employer cannot necessarily search those areas in which you would think there would be an expectation of privacy. They can't go through everything. You're right, it's a question of reasonableness. And I'll tell all of you this, and that's why I don't take them, is that sexual harassment cases are nightmares to bring, and when you ask, almost impossible to prove. That's why it takes real good lawyers like Kerri Riley. And I salute her for it. Thank you.
Well,
so
thank
much
you.
for coming.
But first of all, I do want to thank Alice for letting me come. I really, really appreciate the opportunity to talk to you about a very, very serious problem that we have, and I need all of your help. It's about a drug called Salvia divinorum, but it is not your garden herb. Some of you had said, is this growing in my garden? No, it is not growing in your garden. It's growing in Mexico. It's a plant, and it has an extract. It's called D, and it's shipped here to this country. And you can buy it anywhere. I want to just read you some of the effects of it. First of all, think LSD. Think of it as an hallucinogen. This is what it does for you. You have a sense of loss of body, which means the kids who are using it today lose their sense of gravity, so they have to float around. They have slurred speech, loss of speech. They also feel that they're being underwater in a tunnel. They feel like they're suffocating. They're unable to get off the floor. They're totally confused. And just recently in Arizona, that I just received an article last week, one of the kids in Arizona went into a tent, zipped it up, and then put himself on fire. You can buy it here in town. You can buy it at Smoking Joe's and Zero Gravity. And it's legal. Anyone can go in and buy it. When I found out about it, I never heard of it, and we're supposed to know every drug trend that kids are using. But you know, in this community, I found out that it was a secret. There wasn't any adults that ever heard of this, but all the kids knew about it. And kids are telling other kids that are coming out of treatment, hey man, don't get marijuana. Go buy salvia. It's legal. So when we heard about this, we immediately initiated a public awareness campaign. We first hit the Madison County delegation. We hit them with email, mailings, packets of information. All of you are lucky. All you got were 2 pieces. They were receiving 15, 20 pieces of information about this. We did the state. We contacted Folsom, Riley, Attorney General Troy King, all the state department heads, and eventually the word is out. And as I said, it's legal. But it is not legal in 8 other states, and you can look on your map and see where it is. It is not legal in North Dakota, Oklahoma, Missouri, Illinois, Louisiana, Tennessee, Maine, and New Jersey. And you can smoke it, you can chew it, or you can also taste it. It also comes in liquid form. One of my board members bought it at a board meeting. She just walked in and bought it, and it's expensive, but it's legal, so our kids are doing it. So those are the states that already are smart enough to criminalize this. The DEA is now looking at it as a controlled substance. Now, where is Alabama? Alabama had a bill last year for this, and somehow it kind of slipped through the cracks, and nothing ever happened. So now what we're trying to do is get a bill to prohibit the sale of salvia divinorum in the state of Alabama. Sooner or later, the entire country is going to have this criminalized. But why do we have to wait until some kid thinks he's Superman and he flies off the roof? Because that's what's going to happen one day. So thanks to my friend Alan, when he heard about it, he said, please come here, you need to tell this group about this. I'm here tonight to plead, to beseech you, to please contact your legislature. You can just do Alabama legislature. That's all you have to do is just tap into that on your internet, and they'll tell you everybody who you have to reach. Bombard them with emails. Contact your politicians. Your Madison County people know all about it, but they have 2,000 bills that they're going through. So what I'm here for tonight is to please, please study this, realize how important this is. We don't want to wait till a kid dies from this. So contact whoever you know. Here in Madison, your school superintendents all know, your school board presidents all know. Everybody in Huntsville and Madison County have been alerted to this. But it is a statewide initiative, so I need all the help. We need all the help, because let's not wait until it's too late, and I thank you very much.
Thank you.
God bless America, land that I love. Stand beside her and guide her through the night with a light from above. From the mountains to the prairies, to the oceans white with foam.